There's a letter that shows up in a lot of families' mailboxes, usually a few weeks after a funeral. Most people have never seen one before. It comes from the state, official envelope, official seal. Inside is a number. Sometimes it's 4 figures, sometimes it's 6. That number is what Medicaid says your mother's care actually cost. And now that she's gone, the state wants it back, out of the one thing everyone assumed was already yours: the house. If your mother or father is over 70 and their house is paid off, this applies to you. Doesn't matter if she's still sharp as a tack, still driving herself to church on Sundays. Doesn't matter if long-term care feels like a someday problem, not a right now one. Here's the piece almost nobody explains at the time. Medicaid isn't a gift. When it pays for a nursing home or even certain kinds of care at home, it's not free. It's a loan the state expects to collect on later. And later usually means after your parent has died, from whatever's left in the estate. For most families, the biggest thing left in the estate is the house. This program has a name: Medicaid Estate Recovery, MERP for short, and it exists in every single state because federal law requires it. It's not a scandal, it's not a secret conspiracy. It's just something almost nobody tells you about until the letter shows up. Nationally, a private room in a nursing home now runs over $9,000 a month. Most families can't cover that indefinitely out of pocket, which is exactly why Medicaid ends up involved for so many of us, not just families who were struggling financially before care ever started. And here's the part that catches families off guard the hardest. A will doesn't stop it. Neither does the fact that you've been the one paying the property taxes for years. Neither does, but it was always going to be mine. The state's claim can sit ahead of all of that, unless somebody put the right protection in place years before it was needed. So how does this actually work? Let's walk through the mechanics, because they matter more than the fear does. Medicaid Estate Recovery kicks in under specific conditions. If your parent was 55 or older when they received Medicaid-covered long-term care, nursing home care, and in many states certain home and community-based services too, federal law requires the state to attempt to recover what it paid after your parent dies. Most families think of Medicaid the way they think of Medicare: coverage you're owed, no strings attached. It isn't. Medicare is insurance your parent paid into their whole working life. Medicaid is a means-tested benefit. The government helps because your parent doesn't have the money to pay for care themselves, and in exchange, the government gets first claim on what's left when they're gone. That's the actual deal, even though almost nobody explains it that way at the time your parent signs up. Not every dollar Medicaid spends triggers this either. Nursing facility care always counts. Federal law makes that mandatory recovery in every state. Home and community-based services, the kind that help someone stay in their own house longer, are optional for the state to recover. Some states go after those costs, some don't. One more reason this conversation has to happen with someone who knows your specific state's rules, not a national average. It doesn't happen while they're alive. There's no lien the day they're approved. It happens afterward, against what's legally called their estate. And in most states, that specifically means whatever passes through probate court. If the house is still titled in your parents' name alone when they pass, it typically goes through probate, which typically means it's exposed. Here's how it actually shows up procedurally. After your parent passes, whoever is handling the estate, usually the executor, sometimes just whoever's named on the will, gets a formal notice from the state's Medicaid Recovery Unit. There's a response window, typically 30 to 90 days depending on the state, to pay the claim, negotiate it, or apply for an exemption or hardship waiver. Miss that window and your options narrow fast. Here's the sentence that trips up more families than almost anything else in this niche. We already have a trust, so we're covered. Most of the time, that's wrong. A standard revocable living trust, the kind that mainly exists to skip probate delays, does not protect a house from Medicaid estate recovery. Your parent still fully controls it, adds to it, takes from it, changes it, dissolves it anytime they want. Medicaid treats an asset your parent still controls as still theirs, Fully counted, fully exposed. That's not a loophole closing. It's two completely different legal questions with two different answers, and most families only ever hear the answer to the first one. There are tools that actually work. I'll walk you through exactly what they are and exactly how to start in a few minutes. But I want you to sit with this part first, because it's the part that catches the most families off guard. Nobody in this story did anything wrong. Nobody signed a bad document. They just ran out of time to sign the right one. I want to tell you about Karen, not her real name, but her story is close to word for word one I've heard many times. Karen's mother Diane was 81, sharp mind, lived alone, house paid off in the 90s. Karen checked in every Sunday. When Diane's balance got shaky and a fall sent her to the hospital, the discharge team recommended a nursing home for rehab. Temporary, everyone assumed. Diane's Medicare covered the first 20 days. After that, the bill was $9,800 a month, and Diane's savings couldn't carry it. So she applied for Medicaid, and Medicaid approved her, and everyone breathed easier. Diane lived in that facility for 2 years and 4 months before she passed. Medicaid picked up nearly all of it. 6 weeks after the funeral, Karen got the letter. The state was filing a claim against Diane's estate for $187,000, the cost of 2 years and 4 months of care. And the only asset in that estate large enough to cover it was the house Karen grew up in. The house Karen had been planning to keep, maybe even move into herself one day. There was no will provision that stocked it. There was no revocable trust. Diane's attorney had set one up years earlier specifically to avoid probate, and Karen had always assumed that meant the house was protected. It wasn't. The trust kept the house out of probate court. It never took the house out of Medicaid's reach. Karen looked into a hardship waiver. She'd actually moved back into her mother's house the year before the fall, helping with groceries and appointments and the day-to-day of it. So she qualified for a review. Qualifying for a review isn't the same as winning one, though, and the process took months while notices kept arriving. In the end, Karen sold the house to satisfy the claim, not because a judge forced her hand overnight, because there was no protection in place. And by the time she learned that, there was no time left to build one. Karen didn't do anything wrong. Her mother didn't do anything wrong. Nobody sat down and made a bad decision about the house. The decision that mattered never got made at all. And by the time anyone learned that, the 5-year window to have made it had already closed. That's the story I don't want for you. So here's the move. The one thing that actually changes the story. Step 1. If your parent is currently healthy and the house is still just sitting there unprotected, the single best thing you can do is get in front of an elder law attorney, not a general estate attorney, an elder law specialist, because Medicaid planning is its own niche within a niche. Ask them directly about 2 tools, a Medicaid-compliant irrevocable trust and a life estate deed. An irrevocable trust, done right, takes the house out of your parents' direct control and out of their countable estate, but your parent gives up the ability to change or dissolve it later, which is exactly why it works against Medicaid's rules. The trade-off is real, less flexibility in exchange for real protection. And the clock matters enormously here. It has to be set up more than 5 years before your parent applies for Medicaid, or it won't count at all. A life estate deed works differently. Ownership of the house transfers to you now, while your parent keeps a legal right to live there for the rest of their life. It's simpler to set up than a trust, often less expensive, and in most states it also starts that same 5-year clock ticking the day it's signed. Neither of these is a form you download and fill out on your own. Get this done through an attorney who does Medicaid planning specifically. The paperwork has to be exact, and a mistake here can cost more than the protection is worth. Step 2, and this is the one people skip, do it while your parent still has legal capacity to sign. Once dementia or a health crisis takes that away, these particular doors close. This is uncomfortable to bring up. Bring it up anyway. Step 3, if your parent is already receiving care, or the 5-year window has already closed, you're not out of options. You're just working with a shorter list. There are exemptions the state has to honor regardless of timing, and a hardship waiver process for cases where recovery would create real hardship for the family. I'll walk through both of those next, because knowing they exist is its own kind of protection. The person across the desk at the elder law attorney's office does this every day. You've never done it. That gap is the whole game, and the fix for that gap is one phone call. A few honest edge cases, because this channel doesn't do fear without the full picture. Every state has to honor certain exemptions from recovery, regardless of when they're set up. These aren't planning tools you build, they're built into federal law already. If your parent's spouse is still alive, or if there's a minor or disabled child, recovery is delayed or waived automatically. And here's the one most relevant to a channel like this one, the caregiver child exemption. If you lived in your parents' home for at least 2 years immediately before they went into a nursing facility, and your care during that time is part of why they didn't need to go sooner, the house can be exempt from recovery entirely. Karen's 1 year came close. It wasn't the 2 the law requires, which is exactly the kind of detail worth knowing well before you're the one counting the months. Beyond the built-in exemptions, every state also has to offer a hardship waiver, a process to apply for relief when recovery would create genuine hardship. It's not automatic. You have to ask for it, usually within a set window after the notice arrives. Every state also runs at least a probate-only recovery program at minimum, meaning only assets that go through probate court are fair game. About half the states use an expanded definition instead, meaning they can also reach certain non-probate assets, including some jointly held property and assets in certain trusts. Which category your state falls into changes this entire conversation, and it's exactly the kind of thing to ask your attorney on day 1. And one more term worth knowing before you ever need it, a TEFRA lien. Some states can place a lien on the house while your parent is still alive and still in care, separate from the after-death recovery claim we've been talking about. It's less common, but it's real, and it's one more reason this is worth an actual conversation with someone who does this for a living. Laws differ by state. 1 hour with an elder law attorney costs less than 1 month of probate. Before you close this out, here's your one thing for tonight. You don't need to call an attorney tonight. You don't need to have this whole conversation with your parent tonight. Just ask yourself one question. Does your state's Medicaid program have a hardship exemption for the family home? You don't need the answer right now. You just need to know the question exists, because most people don't until the letter's already in their hands. That letter I opened with, the one that shows up a few weeks after the funeral, it doesn't have to be the first time your family hears about any of this. That's the whole point of tonight's video. Your parents handled everything for you once. This channel is how you return the favor, without losing your mind or their house. Follow along. I'll see you in the next one.